Mental Capacity Act and Deprivation of Liberty Safeguards, DOLS. This is sometimes referred to as DOLS. Every day we make decisions about lots of things in our lives. The ability to make decisions is called mental capacity. People may have difficulties making some decisions either all or some of the time. Managing a situation in which someone you are looking after has a mental health problem is not easy, and although help is offered in the best possible way, this may not always be straightforward. Mental Capacity Act 2005. The Mental Capacity Act is a law that affects people of 16 and over who live in England and Wales. In Scotland, it is the Adults with Incapacity Scotland Act 2000. In Northern Ireland, the mental capacity legislation is currently under review, and a new mental capacity bill is to be enacted in 2011. These acts set out safeguards to empower and protect a person who is assessed as not having mental capacity. The Mental Capacity Act makes it clear that any assessment of a person's capacity must be decision-specific, and this means that an assessment of capacity must be about the particular decision that has to be made at a particular time, and is not about a range of decisions. If someone cannot make complex decisions, this does not mean that they cannot make simple decisions. You cannot decide that someone lacks capacity based upon their appearance, behavior, age, or condition. Those people lacking capacity could include people with a learning disability, a brain injury, dementia, a mental health problem, or a stroke. The mental capacity may be permanent or temporary. People such as nurses, doctors, social workers, care workers, or anyone who is getting paid for the job they do will have a duty to consider the Act, and they must know what the Act says. The Act will also protect people from being badly treated by a carer, which of course would be a criminal offence. It also allows people to plan ahead for a time when they may lack capacity. This is called an advance decision. It allows you to have someone as your lasting power of attorney, or LPA. This person can make decisions for you regarding financial matters, property, or healthcare, if the person lacks the capacity to decide for themselves. There is a code of practice which is the legal framework provided under the Mental Capacity Act 2005, and this sets out best practice. Full details of the code can be found at www.dh.gov.uk. Again, it's important to remember that some people may lack the capacity to make more complex decisions, but can still make other decisions, for example, what to wear or what to eat, or if they want to go out. They must be allowed to do so, and this is also laid down in the Code of Practice. What is an advance decision? There may be times when a doctor needs to treat a person who does not have the mental capacity to decide whether they need or want a certain treatment or not. Advance decisions are made by a person when they have mental capacity. They can make a decision about a particular type of treatment that they do not want in the future. Then, if they lack mental capacity and the ability to make decisions, the doctor must respect any decisions previously made by them. The advance decision outlines any treatment the person wants to refuse and when they want to refuse it. If the advance decision states refusal of treatment which may keep the person alive, this must be documented clearly and signed by the person. Advance decisions can be signed by another person, but this must be in agreement with the person making the decision, and they must witness the signature. There must be an express statement that the decision stands even if life is at risk. People must not be forced to make advance decisions, as it has to be their own personal choice made after considering all the facts. A valid advance decision has the same effect as a refusal of treatment by a person with capacity, in that the treatment cannot lawfully be given. The doctor might face civil liberty or criminal prosecution. The Mental Capacity Act 2005 came into force in April 2007 and forms the legal basis for advance decisions. From April 2007, to be valid, an advance decision needs to be made by a person who is 18 or over and has the capacity to make it, specify the treatment to be refused, it can do this in lay terms, specify the circumstances in which the refusal would apply, not have been made under the influence or harassment of anyone else, and not have been modified verbally or in writing since it was made. What do we mean by mental health? Mental health is a broad term used to describe certain aspects of our everyday lives and experiences, and includes emotional well-being, our ability to experience feelings and to understand and express these. Think clearly, our ability to process information, to solve problems, and to make good decisions for ourselves. Resilience, our ability to deal with difficult experiences, to learn from them and move on. Relationships with others, our ability to form attachments, to make, maintain, and break relationships, to belong, and to manage conflict. And self-esteem, feeling worthy, feeling we have power to control and influence our experiences. When our abilities in these areas are strong and working well, we will be experiencing good mental health or mental well-being. When our abilities in these areas have been damaged or disrupted in some way, we will experience mental health problems. Mental health is influenced by social, biological, and psychological factors, including a person's past and present life experiences and events, for example, how they were treated as a child, the quality of their social networks, and their economic circumstances. Biological functioning of their brain, which is affected by genetic inheritance, hormones, and diet, and individual personality, how they view and respond to the world. Changes in any of these three areas, social, biological, or psychological, will impact on a person's mental health in a positive, negative, or an indifferent way. However, because these factors interact in complex ways, the cause and effect of changes may be unclear. What is the definition of mental capacity, or lack of? If a person has mental capacity, it is believed that they have the ability to make decisions. In order for a person to have that capacity, they must meet the following criteria laid down by the Mental Capacity Act. Understand the information given to them. Retain that information long enough to make that decision. Use the information that is available to make the decision. And communicate their decision by the appropriate means. It could be talking, blinking, using sign language, or any suitable means of communication. However, under the Mental Capacity Act, capacity is deemed to be decision-specific. That means that although a person might not be able to make decisions about their health care, they may still be able to make decisions about other things, such as financial issues or what they would like to eat or drink. Assessing capacity. The Mental Capacity Act states that everyone should be treated as being able to make their own decisions. A person cannot be assumed to lack capacity because of how old they are, how they look, or how they behave. If a decision needs to be made for an individual, the person making the decision must not assume that the person cannot make the decision by themselves because they have a disability, assume that they cannot make more complicated decisions, think that they have not been able to make decisions like that in the past. If there are concerns that a person does not have the ability to make such decisions, then an assessment should be carried out. There are different levels of assessment which depend upon the importance of the decision that needs to be made. If the decision to be made by the person is very important, such as whether to have an operation or move into a nursing home, then an assessment will need to be made by an appropriately qualified professional. There may be times when registered nurses or healthcare assistants will need to assess a person because they need to provide care and treatment. Staff will not be expected to have an in-depth knowledge of how to assess capacity. However, they must have a reasonable belief that the person lacks the capacity to consent to care. The Act is underpinned by a set of 5 key principles, which are a presumption of capacity. Every adult has the right to make his or her own decision, and must be assumed to have capacity to do so unless it is proven otherwise. Individuals being supported to make their own decisions. People must be given all appropriate help before anyone concludes that they cannot make their own decisions. Retaining the right to make what might be seen as eccentric or unwise decisions. Best interests. Anything done for or on behalf of people without capacity must be in their best interests. And the least restrictive option. Anything done for or on behalf of individuals without capacity should be the least restrictive of their basic rights and freedoms. Someone is said to lack capacity if they are unable to make a particular decision. This inability must be caused by an impediment or disturbance of the mind or brain, whether temporary or permanent. Best interests. If a person is unable to make a decision about care, then staff can provide care for them, but it must be deemed to be in the person's best interest. The person must be involved in this process as much as possible. They must be consulted and listened to, and certain things must be taken into account, such as the person's wishes and feelings, an advance decision to refuse treatment, a lasting power of attorney, or whether the person has a deputy. The person who is giving the treatment or caring must follow the best interests checklist. This will enable them to decide on the best care possible for the person. They should also communicate with relatives and friends when the person is unable to communicate for themselves. The relatives and friends can help staff to understand the person, his or her values and preferences, and the type of care that he or she would want to have. When staff are providing care for a person who is unable to consent, they must record this. You will have learnt about the importance of recording and reporting during your induction training. It is important to record all information so staff can access this information to enable them to care for the person, taking into account their values, needs, wishes and preferences. This will include such things as food and drink choices, religion and ethnic views, personal care needs, and many other aspects. Acts in connection with care or treatment. Providing you have complied with the Mental Capacity Act in assessing a person's capacity and have acted in the person's best interests, you can carry out many aspects of a person's personal care without their consent, and have protection from liability in doing so. Actions concerning a person's care that may have protection from liability include helping with washing, dressing, or attending to personal hygiene, help with eating and drinking, helping people to walk and assistance with transport, acts performed in relation to domiciliary care or other services, acts performed in relation to other community care services, such as daycare, residential accommodation, or nursing care, acts associated with a person's safety, and acts associated with adult protection procedures. This extract has been taken from Making Decisions, a guide for people who work in health and social care. Full details can be found by logging on to www.justice.gov.uk. we can see that the Mental Capacity Act provides a framework to help assess whether or not an individual lacks capacity to make decisions. Following on from this legislation, there was a need to protect vulnerable people when their care needs may involve them being deprived of their liberty. For example, a hospital or care home may feel that a particular care plan they are considering may deprive the individual of their liberty. The plan is considered to be in the best interests of the individual, but they are unable to give consent because they are lacking capacity. In circumstances such as these, the individual must be protected, and this is done by using the Mental Capacity Act Deprivation of Liberty Safeguards, or MCA-DOLS. What do we mean by deprivation of liberty? Before looking at the safeguards, we need to consider what this means. A simple definition of liberty may be being free to do what you want when you want to. There are many ways in which an individual's liberty can be taken away in a care setting. For example, is the individual making some decisions for themselves, or are the staff making all the decisions? Does an individual wish to leave the care setting but is not being allowed to? And is the individual not being allowed to see family and friends? If an individual is being stopped from doing things the way they want all the time whilst receiving care, this is a deprivation of liberty. The individual being treated in this way must have a deprivation of liberty safeguards authorization. This is the law. It is accepted that there will be individuals who will need to be cared for in situations where they are deprived of their liberty. Examples of this may be individuals with severe autism, profound learning disabilities, or dementia. Deprivation of liberty should never be used as a form of punishment or for the convenience of professionals, carers, or others. It should be noted that deprivation of liberty is different from restraint. However, some acts of restraint could escalate to becoming deprivation of liberty. It is really a question of degree. However, restraint may be appropriate when used to prevent the individual who lacks capacity from coming to harm. For example, it would be acceptable to prevent an individual who is lacking capacity from leaving care premises to go to the shops on their own, which would involve crossing a busy road. This act of restraint would be seen as in proportion to the risk of the individual suffering harm. Who are the safeguards for? The safeguards will cover individuals in hospitals and care homes or organizations registered under the Care Standards Act 2000. They apply to individuals who lack capacity to make decisions about care or treatment and are there for the protection of vulnerable people. Deprivation of liberty safeguards. In the discussion of these safeguards, you will encounter the following words which need explanation. Supervisory body, which refers to the commissioning bodies. Managing authority, which refers to the person or body with management responsibility for the hospital or care organization in which a person is being deprived of liberty. And relevant person, the person who may be deprived of their liberty. The safeguards apply to people living in England and Wales, people who are 18 years or older, people who have a mental disorder such as dementia or a learning disability, people who live in a care home or are staying in hospital who are lacking capacity to agree to be there. How are the safeguards used? If a care home or hospital identifies an individual who is likely to have their liberty denied, they must apply for an authorization of deprivation of liberty. The Mental Capacity Act will not allow an individual to be deprived of liberty without such an authorization. There are two types of authorization: standard and urgent. What types of assessments are required in order to obtain an authorization? Age assessment, to confirm the individual is aged over 18. No refusals assessment. Mental capacity assessment. Mental health assessment. Eligibility assessment. and best interests assessment. There are standard forms which need to be completed by assessors. There must be a minimum of 2 assessors, and the mental health and best interests assessors must be different people. There are comprehensive guidelines as to who can be a best interest assessor to ensure there is complete fairness and objectivity. These details can be found in the Deprivation of Liberty Safeguards Code of Practice. Age assessment. This assessment is simply to confirm that the individual is aged 18 or over. If the individual is under 18, a different set of safeguards would apply. Age can usually be quickly confirmed by sight of a birth certificate. No refusals assessment. The purpose of the no refusals assessment is to establish whether an authorization to deprive the relevant person of their liberty would conflict with other existing decisions which are in place for that person. For example, the individual may have made an advanced decision to refuse particular treatment. If that particular treatment is the reason for applying for an authorization, it would be refused. Mental capacity assessment. This assessment is to establish whether the individual lacks capacity to decide whether or not they should be accommodated in the relevant hospital or care home to be given care or treatment. Mental health assessment. The purpose of the mental health assessment is to establish whether the individual has a mental disorder within the meaning of the Mental Health Act 1983. That means any disorder or disability of mind, apart from dependence on alcohol or drugs. It includes all learning disabilities. The mental health assessment must be carried out by a doctor. Eligibility assessment. This assessment relates specifically to the individual's status or potential status under the Mental Health Act 1983. A deprivation of liberty authorization cannot be granted if the individual is detained as a hospital patient under the Mental Health Act. Best interests assessment. The best interests assessment would consider whether deprivation of liberty is in the best interests of the individual. It is necessary for them to be deprived of liberty in order to prevent harm to themselves, and deprivation of liberty is a proportionate response to the likelihood of the individual suffering harm. Depriving someone of their liberty is a very serious matter, so the first task of the best interests assessor is to establish whether deprivation of liberty is occurring or is likely to occur. If this is not established, there would be no need to make the other types of assessments listed. A less restrictive option could be found. If the best interests assessor considers that deprivation of liberty is occurring or likely to occur, they should continue with a full best interests assessment, which would include seeking the views of other appropriate people. This would be to determine whether they feel it would be in the best interests of the individual concerned in order to protect them from harm. The people consulted could be family, friends, carers, or an advocate. The names of all people who have been consulted must be recorded in the assessment report. Relevant Persons Representative, or RPR. As soon as deprivation of liberty authorization has been issued, the supervisory body concerned must appoint a person to look after the interests of the individual who has been deprived of liberty. This person is referred to as the relevant person's representative. The RPR is usually a family member or someone known to the person deprived of liberty. If the person has no family member, friend or carer, the supervisory body has to appoint a representative. The role of the RPR is to stay in contact with the individual, and support and represent the individual in matters relating to deprivation of liberty. This person must be independent of the service provider who is caring for the individual deprived of liberty, over 18 years of age, and able and willing to maintain contact with the individual. What the care organisation or hospital, referred to as the managing authority, must do to support the relevant person's representative. Once the deprivation of liberty authorization has been granted, the individual and their representative must understand the effect of the authorization. They must be informed of their right to ask for a review, and complaints procedures must be available to them. The individual and their representative must also be made aware of their right to apply to the Court of Protection to ask for a change or termination of the authorization. The individual also has the right to ask for the support of an independent mental capacity advocate if no RPR is available. When working with the individual and their representative, it is important to remember that communication and language needs must be met in order to make the support effective. What is the role of the independent mental capacity advocate? An independent advocate is someone who supports an individual to make sure their views are heard and rights upheld. They are independent and not connected to carers or services involved in providing the care of the individual. In some situations, an individual may not be able to ask for an advocate, or may not be able to express their wishes. Nevertheless, an advocate can still look after the individual's best interests by establishing an understanding of the individual's needs, wishes, and preferences. This type of service is called non-instructed advocacy. It should be noted also that both the individual and the representative have the rights of access to an IMCA for further support where necessary. For example, if the representative is not professionally trained, they may find it difficult to understand how the Court of Protection works or other legal aspects of the deprivation of liberty authorization. In situations like this, the IMCA can be invaluable. There may be circumstances where an individual does not have a representative to support them. If this happens, the managing authority must notify the supervisory body, who will engage an advocate to represent the individual until a representative is appointed. Review process. The individual should be monitored on an ongoing basis. This is necessary because the individual's circumstances and needs change. The individual's care plan and in what circumstances a review would be necessary. There are statutory grounds for a review, which include: the individual no longer meets the requirements of the original assessments for age, no refusals, mental capacity, mental health, or best interests. The individual objects to receiving mental health treatment in hospital and now would be subject to possible admission under the Mental Health Act. Or there has been a change in the individual's situation which would indicate an amendment to the authorization. Reviews can take place at any time and can be requested by the individual, their representative, the managing authority, or the supervisory body. Court of Protection. The European Convention on Human Rights states that any individual who is deprived of their liberty in accordance with the safeguards in the Code of Practice should have access to a court that can review whether their deprivation of liberty is lawful. An application to the Court of Protection can be made before and after an authorization is given. For example, an individual or their representative is aware that an authorization is being sought, and they wish to ask the court to determine whether or not there is lack of capacity. The Court of Protection can vary or terminate an authorization or instruct the managing authority to do so. More usually, the Court of Protection is asked to look at matters arising once an authorization has been approved. It is obviously beneficial to all parties to try and resolve issues without having to take matters to court. However, if problems cannot be resolved, the individual and representative should not be discouraged from making a court application. Summary. There are several key points for care organisations and hospitals, managing authorities, to consider. Care planning must include considering whether an individual has capacity to agree to services being provided. Also, does the proposed care plan deprive the individual of liberty? An individual must not be deprived of liberty except in an urgent situation, unless an authorization has been granted and is currently in force. All conditions of the authorization must be met. An authorization is for a maximum period of 12 months. Appropriate people involved in the care of the individual must be consulted in decision-making. The authorization should be reviewed before it expires if there is significant change in the individual's circumstances. Any decision to deprive an individual of their liberty can be challenged, and complete and accurate records must be kept of all processes involved in assessment and authorization of deprivation of liberty. You may now wish to complete the questionnaire.